This is Ambrish Saxena and you are watching DME TV. Here we have different kind of programs and this is one important program which is called DME Dialogue, wherein we invite distinguished people who have an expertise in different areas to talk about on diverse topic and to provide such kind of information and knowledge to the people which will be very useful. Today we have Mr. Gunjan Singh with us, who is an advocate in Supreme Court of India and who has done tremendous work in the area of human rights. Welcome Mr. Gunjan Singh in this program. So to begin with, firstly we would like to know, since you have been in this legal profession for long, and besides that you have been taking up the concerns of the societies, concerns of the people, and you have been taking up a lot of issues in the area of human rights. So we would like to know as to how you developed this all, what motivated you to do all this, and how has been your journey in this area?
I think I don't have an answer exactly that what prompted me to take up law, but one thing I was very sure that what I didn't want to do. Yeah. So when I passed my high school, most of my friends used to go for engineering and medical courses, and I somehow didn't like it. I had lost interest in science in my high school, and I always had interest in social issues, not law per se, but I read newspapers. At a very young age, I used very avid reader of newspapers. Every morning I used to read newspapers and had this interest in politics, in social issues. So to that extent my interest was limited till high school, but once I graduated, once I passed high school and was looking forward for my undergraduation, that where do I go and what do I study. During that period of time I did some brainstorming, I met few people, I came to Delhi for the first time, and it was here I met few lawyers and students who were actually studying law. And that conversation fascinated me, and I saw that this profession is actually what I want to do, and that is how I landed up being a lawyer.
So you would have, since you have done a lot of things, so you would have been a lot of interest in the area, and then you would have decided how you can grow up as a better lawyer, wherein you can really serve the society in some manner.
So first was all those politicians, they used to influence me a lot, like all those from since independence we see, all our freedom fighters, our top leadership, they have been lawyers. And I saw a potential in law that if I want to bring a change, somehow make a difference, then I think law is a tool. This degree will, make me, I can learn things and I can serve, I'll have a skill as a lawyer. And I think that is the reason I picked up this profession, because I saw potential in this profession, that by law you can bring change to people's life and you can influence policies as well.
Yeah, and talking about human rights particularly, there's a universal declaration of human rights, then we have fundamental rights in our constitution, all that is there. But despite that, somehow we find that the status of the human rights in India, or the kind of environment which should be there as far as the rights of the people, the dignity of the people is concerned, that is somewhere lacking. What do you think about that?
Very rightly pointed out, and I think it's very pertinent, because so far even if you see the litigation around human rights, till today human rights litigation is not considered as mainstream litigation. Somehow there is a an environment where human rights litigation is considered as some sort of a side litigation. It is not a mainstream litigation. Very unfortunate and not true at all, because in my opinion human rights litigation in itself is a mainstream litigation. A lawyer can do human rights litigation, survive and do best in their profession throughout their journey as a human rights litigator. And we have many examples, not only we have seen many lawyers here in India as well, where people have just practiced human rights litigation throughout. And it has to be considered mainstream, because unless and until we realize that human rights is as mainstream as any other rights,
So how your approach as a lawyer towards litigation of human rights cases is different from the other cases? And I mean, you and so many other advocates in the Supreme Court have taken up these issues. And what kind of approach is there towards the litigant, and how you feel that person comfortable, whether you go some extra miles to support that person, what all you do in that?
See, human rights litigation, I mean, you are right that it is somehow different from mainstream litigation, because somehow in human rights litigation you will have to go extra mile. You have to be little empathetic to the person whom you are dealing with. You have to listen to them carefully, and if required you have to go and see where they live, in what conditions do they live. These practices are not required in any other litigation. Maybe if you are a tax lawyer, you are not required to go and visit people, communities and their house and their villages, or maybe their other households. You don't have to go there and understand. But as a human rights litigator, it is important that you are very much well connected with the society. You are always aware about their situation, and that is how, because that will bring change in your
But
practice.
then litigation is a costly affair for the litigant in India, particularly in High Court and Supreme Court. So how that aspect is handled by you as a lawyer?
See, I am glad that our Supreme Court has opened up gate through public interest litigation. In 90s, 80s, we have seen that there was a new era of Indian judiciary, where gates of Supreme Court were opened, that even merely by a postcard, a case can be lodged in the Supreme Court.
But so I have seen over the years, though PIL is really something good, but then the kind of approach which earlier used to be there of the Supreme Court with regard to PIL, the same kind of approach is no more seen.
I mean, you are partially right that definitely PIL started as a tool to uplift poor and to address the concern of marginalized, but now PILs are also filed by middle class people and maybe sometimes frivolous litigations. No doubt about it.
Because Supreme Court has once said that it's a public, instead of public interest litigation, it's a private interest litigation.
But at the same time, we must be conscious that Supreme Court has been passing wonderful judgments, very powerful judgments, which has brought change to our society, our life of millions of people. We have our historic right to food case, where Supreme Court through its judicial orders ensured that nobody goes hungry, nobody dies out of malnutrition. Unfortunately, the reality is that people have died, but Supreme Court has passed an order ensuring that right to food is ensured in every household. So we have wonderful examples, but you're right that there are few cases where we do.
So, sir, we would also like to talk about the problems pertaining to refugees, and this is a problem which is in a way international problem. Any conflict zone in the world, people are fleeing from one country to another to take shelter, to get the protection, to be safe in another country. And in India also this has been happening a lot, right from 1971, I mean, when this people came from Bangladesh, till recently the Rohingya refugees came in large numbers to India. So as a lawyer, what kind of work you are doing in this particular area, providing some kind of legal support to the refugees?
See, refugees is a very interesting case, and it's not only a problem in India, but it is actually, this debate is very pertinent and relevant when we see the global discourse right now. But coming back to Indian context, it is very important because India is not signatory to 1951 Refugee Convention, and a lot of people argue that since India is not a signatory, even Government of India has passed an order for deportation of refugees.
Yeah, this was pointed out in this Rohingya case. Yeah.
So, but this stand is totally incorrect. Government of India's stand to deport Rohingya refugees is illegal, and I'll explain why. In India, there is Article 21 which guarantees right to life, and it is not limited to only citizens, but every person has a right to life, including refugees. And if you will see India's judicial history, time and again, India's Supreme Court in 1996 in Chakma's case, NHRC versus Khudiram Chakma, they have ensured and they went ahead to ensure citizenship for them. Supreme Court passed an order. Later on in multiple high courts, we have seen how high courts have recognized there is something called principle of non-refoulement, non-return, which is Article 33 of 1951 Convention, which prohibits return to a country if there is a perceived threat
Right.
on different grounds, if there is a threat to life which is perceived, not real threat, which is perceived,
Right.
then also they cannot be deported back to those countries. So, India's stand on refugees, Rohingya refugees particularly, is totally illegal, devoid of any legal merit.
So, but when we look at the Assam, I mean, this national citizenship register is being made by the government. There's a lot of controversy on this, and the refugees have kept on coming for the last 30 years and 40 years in Assam. But then that problem does not seem to be resolved so easily, and the extent that the government of India has taken, the government is bent upon sending them back, whereas the Bangladesh does not recognize them as their own people. So, I mean, what is going to be the fate of the people who are living in Assam?
One important thing I would just like to point out, NRC is different from refugee crisis.
Okay.
People who came from Bangladesh are not refugees.
Okay.
They are economic migrants, and 1951 Refugee Convention protects the refugees. So, Rohingyas are a separate lot. People who have migrated from Bangladesh into Assam is a different lot. These are economic migrants.
Okay.
Right to life will extend to these people, refugees, but migration for economic reason is a subject which is totally in conflict with a state's sovereignty. India has every right, but at the same time, as a matter of caution, the India's practice of NRC is deeply flawed for the reason that the Citizenship Amendment Bill and the way it is being done, it has brought severe damage to communities. Kids are in detention center, people are in detention center for ages, in a one of the most worst condition in detention centers, which Supreme Court has recognized. These detention centers are actually in a very bad shape.
So, can you make some distinction legally, particularly between the refugees and the migrants?
Yes, of course, because refugees are covered by 1951 convention. The principle of non-refoulement, non-return to the place where they have a perceived threat of life will apply only to refugees, but not to economic migrants. So, a state which is sovereign, India has every right to say, hey, hello, you are not invited because this is not a country, we are struggling with job opportunities. You can put a ban on entry of people who are looking for a better life for economic reason, but you cannot stop people who are fleeing their country to save their life, because that is a separate category. There is international jurisprudence which says that you cannot return them on their borders. It is not, a lot of people think that non-refoulement will only apply when the refugees come inside your country and you cannot report them back. Whereas, if you see the international jurisprudence, it has gone to an extent where they cannot be returned on their border. If they are at the border, you cannot return from there also. So, merely entry, there is one step ahead of that, that even entry cannot be stopped.
So, what kind of issues will arise or arises because of the statelessness of such people, and because of their losing citizenship of the country from where they have fled and the country where they have taken shelter? So, pertaining to, I mean, if you can define or you can discuss the citizenship issue of such people.
See, if you will see, just take the example of Rohingyas. They left Myanmar. They are not considered citizen there.
Yeah.
They have a special status there. They flee from their country. They come back to India. Here also they are not citizen. And when you know that when you are not a citizen, you cannot claim all rights guaranteed under the Constitution of India.
Yeah.
You will have basic facilities, few rights to sustain. Right to life is one of them. So you can ask for basic amenities. You don't have right to vote, because you are not a citizen, and once you don't have a right to vote, how do you bargain with your parliamentarian? You cannot bargain because you don't have any right to vote.
Yeah.
So, maybe you will have a minimum sustenance where you can just sustain yourself, but all other rights you will be never getting. Right of employment, right to vote. These are rights which is only available to citizens, and that extends to only citizens. And statelessness is actually a situation where that person cannot claim as a matter of right these rights.
So, it is the discretion of the state where these refugees would have taken shelter, whether that state decides to give them the citizenship or not.
Totally.
Yeah.
It is totally the discretion as a sovereign state.
I mean, there is no international obligation.
There is no international obligation to provide citizenship.
Yeah.
You can give them a visa to stay because it is a temporary arrangement. where you, and it has to, because India is a country which doesn't have enough resources. So, India will have to ensure that their life is protected. Once situation is normal, they can be sent back, or they can be sent back to any other country if that country is ready, because international convention talks about these provisions, that in consultation with a third country you can be sent back. The purpose is not actually to ensure citizenship in one country, but purpose of refugee convention is to secure life of the refugee who is fleeing their country, home country, out of fear, out of threat of life.
But how do you look at the example, as earlier also we referred to Assam? If government is treating some set of refugees as refugees and another set of refugees as migrants, and giving citizenship to one set, denying citizenship to another set, whether this kind of arbitrary approach is acceptable?
This is totally unacceptable, and I think the Citizenship Amendment Bill, as rightly being protested, it has to pass the constitutional test, and I am sure this will not pass the constitutional test, because this is on the line of religion, and that is not permissible, because our constitution does guarantee secular principles, and no discrimination can take place on those lines.
Thank you, Mr. Gunjan, for enlightening us on such vital and complex issue. Thank you for this. So, that was Mr. Gunjan Singh, who is a lawyer in the Supreme Court and who has done tremendously in the area of human rights and the issues of migrants. So, this was program DME Dialogue, and you are watching DME TV.